I'll call this meeting to order. It's Committee of Adjustment meeting. The meeting will be streamed live and recorded for public viewing on the town's YouTube page using the following link. I think that's advertised somewhere, isn't it? Do I have to say it?
The link?
Yeah. I don't need to say that, do I? No. Okay. Applicants, proponents, and delegates must make a request to mbaird@plympton-wyoming.ca to receive instructions on how to attend a meeting virtually as a participant. Anyone who has a declaration of pecuniary interest to declare it at the appropriate time. So the first motion is moved by Les Goldhawk, seconded by Mr. Vasey, that the minutes of the regular Committee of Adjustment meeting held June 11th, 2024 be approved as presented. All in favor? Thank you. Move on to one of our only application tonight. B-1724. That the report by Randy Burke dated July 2, 2024 be received, and that the location is 6796 Wellington Beach 2. Consent application B-17 requesting permission to sever approximately 3101 square meters from the lands known as 6796 Wellington Beach 2 be approved. Subject to the following conditions. Will I read this whole?
Yes,
first?
Sorry.
I have some questions, if anybody wants any questions.
Usually you receive the report.
Okay,
Sorry,
so
I
I'll
don't know how
read.
the motion was written. I'd have to see it across you here.
Says be received and not. Pardon? You want to read out? Mr. Vasey, read. That the owner satisfy the Plympton-Wyoming Public Works Departments that water and sanitary service connections be provided to the lot in compliance with the streets bylaw. That the owner satisfy the Plympton-Wyoming Public Works Department with respect to individual accesses being located on the severed parcel and installed in compliance with the streets bylaw. A cash in lieu of parkland dedication fees paid prior to the stamping of the deeds. The fees to be calculated as per the Planning Act, and the value of the land is to be determined by an appraisal carried out by a town appointed appraiser. The applicant is responsible for all costs associated with the appraisal. All Drainage Act assessments applicable to the lands be reapportioned between the retained lands and the severed lands, according to the agreement provided by the town and signed by the respective property owners of each of the retained lots and the severed lands. If the parties cannot mutually agree to the apportionment of the town does not approve, or if the town does not approve, the town shall instruct an engineer in writing to apportion the assessment among the parties into which the land was divided. Oh, I guess it's the parts, sorry. Into which the land was divided, and the applicant shall pay the engineering fees for such apportionment. The fees will be paid prior to the stamping of the deeds. Number 5, certified lot grading plan to be submitted to the town of Plympton-Wyoming for both the retained and severed parcel, and B, to the satisfaction of the town of Plympton-Wyoming. Number 6, a copy of the final RD plan or survey be submitted to the town of Plympton-Wyoming. Number 7, a copy of the deed and survey must be submitted to the Secretary Treasurer in a form suitable for registration. Number 8, additional severance fees as required by the town have been paid before the documents will be endorsed. Water and storm sewer services must be installed to property line by, just a second, I've got something in front of my here, means of service installation application in accordance with the streets bylaw. That is the end of that. The conditions must be met and the survey indeed be presented within 2 years from the date of decision, or the consent will lapse. Does anybody, would you like to make a presentation on your application? I presume you're Mr. Willett.
I am what I am. I'm not sure what the process is.
Well, you'd like to justify what you're doing, what you're trying to do.
Sure. Thank you. Yeah, so my name is Andre Willett. My wife and I own the property at 6796 Wellington Beach Road 2, which is essentially Egremont, and it's a whole stretch between Egremont and Wadena Streets along Wellington Beach 2. So we have currently 2.12 acres on that property, as you can see on the design. Our house and garage are situated on the north end of the property, the upmost north end. Approximately 40 meters from Dana Street is our front of our house. And so there's a whole approximate acre on the south side that we just don't have a use for, and don't have a need to retain. So we thought it would be advantageous to sever that acre or that portion. Originally, we had anticipated a whole acre, but given the certain official plan requirements, we've come up with a plan that would allow us to sever approximately 3/4 of an acre in an irregular shape to satisfy the zoning bylaw official plan, and at the same time retain access from Egremont to our property on the south end, on the north end of the property.
Okay, thank you. Do any of our committee have any questions? Randy? You want to go ahead and give some information here?
Sure. So thank you, Andre. Kind of will overview the lot layout. So in terms of planning policies, the proposed severance does generally meet the policies within the county official plan, town official plan. I guess I'll just go into kind of why we have this specific lot configuration. So it's county official plan, town official plan, etc. It is required that, could you just go up one more, Mackenzie, sorry? It is required that frontage be had onto a public thoroughfare, not necessarily just access, but frontage. So that's why this is left here. So Dana Street and Wellington Beach Road are private roads, of course. So to split it in half or any other lot configuration wouldn't meet the requirements set out in the official plan. The requirement could ever come into place if Wellington Beach Road were to close, then access at that time could be acquired through the town. However, based on the severance, so the severed parcel will provide access onto Egremont Road, but the retained parcel, it will remain that their current access will be where it is. There is a provision within the zoning bylaw that, although wasn't in the report, it does state that existing lakeshore communities can keep their access on a right of way. So therefore, that access will remain. And although it is creating a new lot, we are thinking that it is kind of the existing condition. If there's any other specific questions, I'm happy to answer them.
Mr. Vasey, do you have any questions?
I've got a couple. Is this lot, is it part of the original Wellington Beach subdivision or whatever they called it back in the day? Is this off of Egremont itself? I'm assuming it is, because it has
I
that.
can answer that.
because
I'm
it's got
sorry.
access.
It was off of Egremont. Wellington Beach is a subdivision and they're all north of Dana and Douglas. So
then he does have access to the private road, but he's not part of the Wellington Beach. Is that? I'm just like, is there an association?
So the
agreements or any of that kind of stuff in place?
So an access agreement, I'm not sure if you have one, in terms of the definition of existing lakeshore community, which is what is kind of referred to in the zoning bylaw, there was no specific definition. But I guess we had just determined that based on the area of the property and the fact that the access was existing through planning as well as public works, it deemed that the access there could remain.
I can respond to the association question. Yes, there is a road association. It's called the Wellington Beach 2 Road Association. And all 11 residents on Dana and ourselves, we're the only ones on Wellington Beach, are part of that association. And we pay an annual fee, we set an annual fee. We pay it to the treasurer to maintain the road and plow and grade and cut shrub and so on along the road. The actual property owner is two properties west of Wellington Beach 2, which is
Yeah.
Mrs. Bentley now.
So I'll have. Thank you.
okay, how about Mr. Goldhawk, do you have any questions?
Just to follow up on Mike's question, just to be clear. So like you're a part of that Wellington Beach, so is that a legal access that you have? That fronts onto Wellington right now? Like,
I suppose that depends on the definition of legal. I mean, it's been, that house has always had access from Wellington Beach. And the address was assigned Wellington Beach when the house was built in 1978. I don't have a deed, I don't have it on my deed that is a legal right of way to that property. But none of the of Dana Street residents have that on their deed. It was part of the original plan of subdivision in 1929, and it says, I actually have a copy of that. It says that road is reserved for the residents of the subdivision.
so in your mind, like being part of that Wellington Beach roadway allowance, you know that, like, you have the access rights.
That's correct. Yeah.
I think I had this answered already, but I'll ask it anyway. Is that the services running back there, I believe, are on that Wellington?
So yes, the services for the subdivision do run through both Wellington Beach Road and Dana Street. There's sewer and water running through those areas. The town has legal easements over those areas as well to provide that service.
Well, Randy, you were saying that the official plan shows that the new construction needed to front on to Egremont Public Road.
Yeah, so in the, that's stated within the county official plan and the town official plan. Because this lot right now already has frontage onto Egremont. You know, we can't take away if we were to kind of cut it. Because these are considered private roads and not deemed public thoroughfare, we wouldn't be able to have. It would kind of be like creating it's not landlocked because there are private roads, but through planning, it would be considered landlocked. So that's why, if it was a lot that was already only fronting onto a private road, it would be, there are different policies associated with that, but because this specific lot had that frontage on Egremont, we can't remove the sole frontage. And that's why Egremont would be deemed it's their front yard and not necessarily Dana Street.
But kind of a follow-up, just because the house fronts onto, well, the house access goes on to Wellington Beach Road now. And that's not going to change, I believe.
It's not recommended to change.
So it's actually the only new construction is the front part of that, the newly set up lot.
Yeah, so the severed lot, so this would be like the new lot creation. And this would have access off of Egremont Road. But like I mentioned, there is a policy in the zoning bylaw that does allow for, it is defined as existing lakeshore communities to have access off of a right of way. So although we're requesting that, you know, he remain an access point, should that ever be required, if Wellington Beach Road ever closed, anything like that, then an access could be put in. We're not requesting that the access that's up here be removed at the moment, due to that specific policy in the zoning.
Because it's a private road, and I know that there's more than just one on there. That by closing that would affect a lot more than just this one.
Yes,
But having just the new construction being I'm gonna call it the front of the lot. Is there a need to have that access going to the old, going to the existing house from public?
sorry, can you repeat?
Is there Is there a requirement or a need to have that frontage? When his access is off Wellington,
So I guess when you look at it in terms of if we're not requesting the access to go through, but through the OP, we're creating a new lot. So creating a new lot that doesn't have frontage onto a public thoroughfare, like I said, through planning would be deemed creating a landlocked parcel, onto roads that the town doesn't take care of or own. But again, we are allowing that access to remain because of the specific policy that says that, in the case of existing lakeshore communities, all uses, buildings or structures shall have frontage or shall have access to a street or right of way, especially in the existing lakeshore communities. It states specifically a right of way.
Okay.
Just want to,
Go ahead, Maria.
I just wanted to interject and add that if this is a bit of an anomaly, because it's not part of the Wellington Beach plan of subdivision. So I think it's just trying to look at it in terms of being flexible and, you know, ensure that it complies with the policies, but the zoning allows for that caveat. So it's just, it's a bit of an anomaly. It's not something that we see a lot of, because technically the lot itself and the house that's on there, the access should technically be off of Egremont.
Yes.
But it's a pre-existing situation, so, and it's been there historically for over close to 50 years, so I think that provides a little bit more.
I think the point is that you're changing the dimensions of a lot. Now you're creating two new lots rather than just one. So then both lots are now on public roads. So should both accesses, the brand new lot, of course, it's going to be an access on the public road, but should the retained lot have access on the public road also? Because you're creating a new lots are not allowed to have access on private roads. So that's what the question is, and can you answer that?
well. I'll let you.
Yeah, you can change it in a minute when she answers this one, okay?
So yes, through your chair. It depends, like I said, this recommendation is based on the fact that as Maria stated, the policies and the zoning are, I guess, a little bit more flexible in terms of access onto a right of way for existing lakeshore communities. I guess, as Maria stated, to provide that flexibility, we are allowing for that access to remain, considering it is existing. It's not adding any extra traffic to the road. No new dwelling will be constructed to access the road. So I guess that's how we view it. However, we did want to request that the frontage remain onto Egremont should in the future, although the closure of Wellington Beach Road would impact a lot more and may never see the light. If it did, then there is a solution there for the future.
Basie? Oh, sorry, did you want to finish up on that?
Yeah, I had a follow-up.
Yeah.
My question was more to the fact that the existing house.
Mhm.
That severing off that piece of property that's fronting Egremont. The existing house is a new lot.
So technically, because we're changing the lot parcel, they would be deemed two new lots. So we would have the retained, although, you know, there's no new development in terms of structures being built. We are changing the lot parcel, so that would be the new retained, and then this would be a whole new separate lot. Technically through planning, how we view it.
That's the wording that stops it from just being severed in half.
Yes, and so like I said, severing it in half because you're, yes, creating a new lot. A new lot can't front onto a public or a private road essentially. Through the policies.
Okay. Mr. Basie, you had a question.
So the existing house right now has an address of something Wellington, 62s, whatever it is. So now I'm coming in a fire truck. Where am I going? Because the new lot address will be Egremont Road. would have to be.
Correct.
So it's gonna be 9, whatever. Egremont Road, I have no access to the back unless I know it's in behind.
No, hang on just a second. Can I answer that? Because yes, his frontage is on Egremont
911
Road. That's where
address.
his access is though as well.
But how
That's
does
where
the
the-
fire truck know that?
Well, Wellington Beach.
But his address will be
The
911.
retained parcel would remain addressed to Wellington Beach, because I believe that's where your access currently is. Until such time that he no longer has legal access to it, then he would have to install an access to Egremont Road, as well as approach the county about a 911 number address change.
The fact that we're creating 2 new lots, will he not automatically be on Egremont Road?
No, because your address is developed by your access point, not necessarily your frontage point. So the address for the retained parcel would remain the same, and there'd be a new address applied to the separate parcel.
This frontage on Egremont Road is only to legalize getting a severance on this property.
That's-
So, and then the screwy lot line goes along with it, so. I just have to say that. You have any questions?
I just have a couple things. Hi, Andre, how you doing?
How are you?
Um, this is unique, but at the same time, we're creating 2 new parcels. So with creating 2 new parcels, the retained parcel is coming off of a private road. So I see a temporary, maybe a permanent fix if, Andre, if you're able to get some sort of agreement with Wellington Beach Association that you have access off of there. And then the new parcel would have access off of Egremont Road. So if we could add a condition that the retained parcel get, have an agreement with Wellington Beach Association to continue the use off of Wellington Beach #2 for your current access. If we don't have, like, if there isn't an agreement already on file, maybe there is, I don't know, but maybe the land registry office would be able to determine that. At the same time, Dana Street, is that private?
Yes.
That's private too. So we essentially are landlocking that property because they don't have access to a public road.
If we were to cut it in half, correct?
It does now, though, if we allow this severance.
Yeah.
So, and if legal access is a concern of the committee, maybe the best way to resolve that would be as part of your conditions, as you mentioned, to make a requirement that either they install a culvert and an access off Egremont Road, or provide evidence that there is legal access off of Wellington Beach Road to the existing dwelling.
Yeah, legal, I think we do need to, protect future. You know, if that association isn't gonna be there forever, then we need to make sure that Andre's property continues to have access. So I think we need to be aware of that and have something put in place. And whether the culvert gets installed at Andre's expense or Wellington Beach, that's something the 2 of them can,
I'm sure Wellington Beach will not. do
no, I'm
that,
sure
but-
not.
And Ms.
Yes,
Burke,
sir. Oh,
they have how many years to get the deed stamped before the severance lapse?
2.
2 years, so the property owner would have 2 years to either confirm legal access or work out a legal access agreement with Wellington Beach, or to install the culvert.
So I have a second question too. Was Wellington Beach Association circulated on this notice?
Believe they would have fallen within the mailing area, so I believe they should have been, but I can double check our mailing labels and see.
Because I'm not sure how we can make a decision without Wellington Beach Association being confirmed that they were received notice.
Which brings us to, did we have any other correspondence?
We did, through chair. we
Challenge with
had-
the beach association is whether they are a legal entity or.
It doesn't, if they're on the property roll, you just send it to the property roll.
Yeah, if they're on a property roll, they're a legal entity.
Through your chair, before Lisa had went on maternity leave, I did have a conversation with her to ensure that they were circulated. At the time, she said they were being circulated. But Mackenzie should definitely confirm that information, but you know, we did have a conversation about it, so.
Mr. Roulette would like to say something.
Well, I mean, I think everybody's on the same page in terms of the technicality, which is causing this odd shaped lot. It remains our preference to have the front acre completely separate as 1 acre. I think, Ms. Berg's been very helpful in this process and this is not a criticism, but I think there's an over application of caution. And I think there's also a technicality in this, in that, you know, are we creating 2 new lots, or are we creating 1 new lot and a retained lot? And that where it says vacant at the top, where that property is on the corner of Dana and Wellington, they would be allowed to develop that property on a private road because it's an existing property on an existing lot, on existing private road, existing property, yet ours is already an existing development on an existing private road. So technically, it's being considered Egremont as frontage, but really we should have Dana Street frontage. So I feel like, and the overcaution part is that, you know, that Wellington Beach has been there since 1929. Sure, it is a private road and something could happen, but as was mentioned, this is a much bigger issue for municipalities. Should that access to that road be taken away somehow by the owner? And just to speak to Jen's point, it's not the Wellington Beach Road Association that could give access because we don't own the road. Mrs. Bentley owns the road. There have been discussions with Mrs. Bentley in the past. She's not what I would call amenable to that discussion. So,
Unfortunately, inherently, that confirms the committee's concern is that legally the committee cannot grant severance if there's no legal access to it. So, given that it'd be very challenging to prove the legal access unless it's identified on your deed, it may be best to amend the conditions to note that either an access to the retained land be installed on Egremont Road, or evidence of legal access off of Wellington Beach be provided. And that'll give you the opportunity to have your lawyer do a deep dive into the registrar office, see if they can pull the original deed, which may or may not give you access. And if that fails, there is the opportunity to, through our streets bylaw, to apply for a culvert entrance to be installed to the front of your property. And then the culvert entrance is there. I don't know if the committee has the appetite necessarily to force you to use that culvert, but it's there. So you have legal access, you have built-in access. So if the day came where the current owner said, no more access, everyone's got to figure it out who doesn't have legal access, you have an entrance way that you can start to utilize.
right. And I would have 2 years to satisfy that condition.
Yes, sir.
So any other questions on this application? Are you in agreement that we will add that condition? And did you note that, Mr. McBaird, that try to change that? Mr. McKenzie? Anyway, so are you gonna add that? Can I hear? We haven't got.
Probably want to bring up the motion that has been provided. You'll want to type in that change. That way the committee can reread it,
Right.
and pass the motion as required.
So, while Jared is doing that, I think we got another thing on our agenda that Councilor Rossi would like to address. It's bill number 185. That was very interesting.
Thank you, Madam Chair.
Can you give us a Reader's Digest version?
Yes.
Very good.
Bill 185 came into effect in early June of this year. And it's the province's latest efforts to remove barriers to reaching its goal of 1.5 million new homes by 2031. So this bill amended approximately 15 pieces of legislation, of which the Planning Act and Development Charges Act are 2 that are mentioned in this report. So in terms of the Planning Act, these are some of the main highlights. If you have additional questions afterwards, and certainly I'd be happy to answer your question. Third-party appeals for official plan and zoning bylaws and their amendments have been eliminated. Appeals can only be filed by a registered owner or specified persons, including the municipal authority and Minister of Municipal Affairs and Housing. Third-party appeals filed with the OLT prior to the passing of Bill 185 are deemed to be dismissed as of June the 6th, unless they have a hearing that was scheduled before April 10th of this year. There's been an expansion of the definition of specified persons, and they've included some federal bodies like NAV Canada, airport authorities, and some aggregate and environmental compliance permit holders that are within a specified distance of the property. Application fee refunds for zoning bylaw amendments and site plan approvals are not rendered within a specified time frame have been repealed. So refunds continue to apply to applications that were filed before June the 6th. Municipalities' ability to require pre-consultation has also for applications for official plan amendments, zoning bylaw amendments, site plan approvals, draft plans, subdivision condominium has also been repealed. So pre-consultations now are considered voluntary. Paperwork will be amended by staff to reflect that. However, the paperwork will reflect that it is still highly recommended to complete pre-consultation, just because that will in the end save the applicant time and money. We are able to provide assistance in the process itself and the various steps and requirements. And I think that that's invaluable to applicants to have a sense of what's expected. And in turn, it holds everyone accountable equally in that regard.
Just for that, Maria, will there be also a space there that says that the pre-application consultation has been declined by the applicant?
That's actually a very good point. I think we will consider that. I think that's an excellent point to put that there so that it's understood that that was offered, and if the applicant chose to decline, I think that's a good idea. Yes, unless
Every once in a while.
no, I haven't seen that, and I think that that's a very valid point. So thank you very much. Yes, I believe when we update the paperwork, we will be adding that to it as well. It'll just be a check mark that they would put in a box. So thank you. I appreciate that. That's a very good point. So there's been a lot of discussion about expansion for settlement areas as well as part of Bill 185. So applications now for official plan and zoning bylaw amendments that propose to add land to a settlement area can now be appealed to the OLT. There is an exception in Bill 185 in terms of that, but it applies more to like the GTA for the Greenbelt area. But I always indicate the exception because in case there's any questions about that. There is a use it or lose it provision, which I think is something that's been a bit long overdue, that allows municipalities to implement a lapsing period for site plans and plans of subdivision if a building permit is not issued within a prescribed time frame. Now, at the County of Lambton and in most of our municipalities, we always did put a lapsing provision for both those types of applications. So for site plan, usually they had to meet the conditions within 2 years. And with the draft plan of subdivision, it was usually 3 years, and sometimes it was 5, just depending. The Planning Act does offer some flexibility in terms of timing if the plan subdivision or condominium required, let's say 5 years as a reasonable time frame to meet the conditions, then that is, but the standard one is normally 3 years. Now, with Bill 185, they're saying it can't be less than 3 years. So for both of those, so in terms of site plan, we have just recently completed one, and we've amended that to reflect the 3 years. And it's also it's something that I think is important to note, especially with the priorities for housing and the various plans that are in the works in the municipalities. You don't want one proposed plan to hold up capacity. and hold up development when other developers are ready to proceed, and other developers may not be able to proceed because there may not be available capacity at that time. So it gives the municipality, the county a little bit more flexibility when looking at extensions and moving forward with those. We have, the ministry has now established a minister's zoning order framework, which sets out the process and requirements, which previously it was a little bit unclear as to that process. So now they've set a framework up for that. Post-secondary institutions are exempted from the Planning Act now, and I think that was mostly in an effort to address housing for students at the post-secondary level. That seems to be the material that has been described in terms of that exemption that's now provided. So with Bill 185 and these other ones that I'm going to discuss, there are no ministerial regulations currently in place for these other items, but the Bill 185 does give the minister now additional powers to make regulations to exempt community service facilities, including school boards, long-term care homes, and hospitals from all or part of the Planning Act. Also, minister can make regulations exempting detached, semi-detached, or row houses from either zoning or site plan if certain criteria are met. And that also includes for additional residential units. But as I stated, the regulations have not been established quite yet in terms of that. It just gives the minister the power to step in if they wish to do that. In terms of the Development Charges Act, the mandatory 5-year phase-in of development charge increases has been repealed. The phased-in rates continue to apply to development charges imposed between November 28th of 2022 and June 6th of 2024. If municipalities have development charge bylaws where they've updated that to reflect the 5-year phase-in, then they have 6 months to amend their bylaws. And they can include study costs to adjust their bylaw rates because studies including development charge background studies now have been reinstated as an eligible capital cost, which I think is something that most municipalities are happy to see come back in. Development charges for zoning bylaw amendments and site plan approvals are frozen if building permits are obtained within 18 months, and that's a decrease in time frame from the previous 2 years. So those are the main highlights. If there's any questions, I'd be happy to address them.
Do you have any questions, Mr. Goldhawk? Got it all down, Pat?
Oh, yeah.
Ms. Vacy,
I'm good, thank you.
Mr.
Not with Bill 185, I don't. I
Not
do
with-
have a follow-up for Andre when we go back to that.
Okay, sure. So, thank you for updating us on Bill 185. We all stayed awake.
Try to be brief.
Yeah, I'm sure you were as brief as you could be. Yes, thank you. Oh, just a minute. I think we have a motion to that effect. No, for this, yeah. Moved by Mr. Goldhawk, seconded by Jennifer Turk, that the report by Maria Cosa-Rossi, Senior Planner, dated June 13, 2024, regarding changes made to the Planning Act through Bill 185, cutting red tape to build more homes Act 2024 be received. Anyone in favor? You carried. So now we'll go back to our application, and there's a condition been added to it, which is evidence of legal access to the right-of-way for the retained lot be provided to the town of Plympton-Wyoming, or access be installed off Egremont Road as per the streets bylaw for the retained lot. And the rest is stayed the same. Is the mover and seconder okay with all that? That was Mr. Goldhawk and Mr. Vacy. Okay. Everyone in favor of this? Carried. Names on Mr. Goldhawk has a long name. Not gonna get rid of that one. So, I think we come to the end one. Oh, yeah, you wanted to continue.
I know, Andre, in one of your comments, you mentioned about the vacant lot that's beside 3200 Egremont Road that could be built upon. Just so you are aware that actually can't be built upon at this moment because it's the same roll number as the property north of Dana Street. So there'd have to be some planning finagling that would have to allow that vacant property to be built on. Now, having said that, there is a vacant property to the east of that. That is a separate pin, a separate roll number, but they would probably struggle to build on that because of our streets bylaw. So there would have to be some sort of finagling in order to get to a public road in order to build.
Thank you.
I just don't want you to think your comments were just ignored, so just so you know.
Appreciate that.
Yes.
Well, thank you, Mr. for giving him his. So we've come to the end of our session, right? If I missed anything? Okay. Moved by Mr. Vacy, seconded by Mr. Goldhawk, that the committee adjustment meeting be adjourned and the next meeting be scheduled for August 13th, 2024 at 5:15 p.m. Everyone in favor? Good. And there we go.